Any mention?
Yes.
Your Lordship, I beg to mention item number 12.
Yes.
Lordship, I pray that this matter may kindly be taken up after 2 weeks.
Yes, sir. Yeah.
The state is the petitioner.
Yes,
No objection, Lordship.
no objection. Take it after 3 weeks. Yes.
Lordship.
Prepare yourself. Yes, no point adjourning it repeatedly. Yes, on the prayer, Dr. P. Agarwal, list the matter after 3 weeks. Yes. Yes.
Obliged, Lordship.
Yes, MS
I
Arbor.
beg to mention item number 9 and 10. My lord.
Why?
Let it come after a week.
Other side ready, Dr. Mozika.
But it's okay. There's signature on this.
In this one, they can't. Now they went for appeal, correct?
My lord. Here, my lord, we challenge the order passed by the appellate authority.
But then there was orders of this court also where you had agreed to a certain kind of payment schedule. Are they sticking to that?
They've not.
So after not sticking to the, we came for division bench here, after not sticking to the modalities that have been given by the court, now you're going around and challenging the appeal. So what are we to do?
Next week, my lord.
Next week, we'll give you 2 weeks, yes. 2 weeks, Dr. Mozika?
2 weeks.
Yes, 9 and 10, 2 weeks. Yes. But he's not here, we'll teach for teachers.
Item number 1.
No.
No, not there, who is there?
Lordship, I am supposed to file rejoinder in item number 1. I'll be filing it during the course of the day.
Yes.
It's only on the maintainability issue, the rejoinder.
Yes, MS P. Agarwal or Dr. P. Agarwal, Learned Counsel of the Country submits that the rejoinder on the question of maintainability will be filed in the course of the day. Yes, after 3 weeks for the consideration. Yes.
2.
Yes, division bench, there are no.
Your Lordships, I filed the rejoinder on 23/6/26. So pleading is complete and it may be placed for hearing. My lord, these other 2 matters, similar matters, fixed on Thursday, 16/7. So this may also be taken with that because similar matters.
Mr. Enda Gupta, some of the pleadings are completed. This is matter for hearing along with other similar matters,
Yes, madam.
which are
Fixed on 16/7, Thursday.
Case number. Just hold case numbers.
Much.
3.
Lordship, the affidavit in opposition will be filed during the course of the day.
yes, who's appearing for? Oh, you're there, Mr. Pare. Yes, Dr. P. Agarwal, counsel for the respondent, submits that the affidavit be filed in the course of the day, just after 3 for joinder of any. Yes.
Obliged, Lordship.
4.
May please, Lordship.
Yes.
Lordship, the affidavit is ready. Lordship, we're filing it course.
Ready for argument on interim orders today?
Lordship, the learned advocate general is on legs before the Honorable Supreme Court, Lordship. So,
On the last occasion, it was said that everything will be done and we'll finish this matter today. So I was expecting it to happen. At least there's no problem if he wants to file reply, but my lord, at least in regards to the stay, your lordships will have to consider it and say.
That, see, we already gave you a long date, 11/6, more than a month.
Yes, ma'am.
We're supposed to file your affidavit within 2 weeks and a joinder 2 weeks thereafter.
Yes.
my lord.
So what are we to do?
My lord, we're filing it in the course of the Lordship. If my friend, another senior is requesting for stay, my lord may have it tomorrow. Since my lord, I'm a bit handicapped today since
Tomorrow, if we don't, this bench not available.
my lord, and then I'm a bit handicapped since the learned advocate general's on legs.
Yes, we understand. We're not compelling you to argue the matter. Only that But you have to file this. You have to file a rejoinder also. That is the issue.
Depending on whatever the grounds are to be taken, yes, I would. So
we'll.
that what was the
be on
reason why a
safe side,
longer date was given.
We'll keep it 2 weeks then. Yes.
Only thing is, Your Lordship,
submit that the affidavit on behalf of the respondents be filed in the course of the day. Stop by order dated 11, next paragraph, 6/2026. This court had let's forget it then. Let's not make the order long. Yes, a list after 2 weeks. Rejoinder may be filed in the meantime.
Right?
Your
Lordship should be fixing a date if it is not inconvenient. I'll take a date convenience. Extremely grateful.
Right.
My lord,
Two matters, 4 and 5 are two.
4 and 5 connected.
Filing the affidavit there.
In both.
But why are there two petitioners?
There are two different associations, my lord, who file it. One is Reboy.
Identical, totally.
Yes, they are all been agreed by it. So the same notifications are challenged by two different associations. Grateful.
I oblige.
6.
Maybe His Lordship. Lordship, in this matter, we were supposed to submit a compilation with regards to all the orders and notifications.
That has been done on the last date, madam.
My lord, we have served the copy on the R7. My lord, we have yet to serve it on.
Yes. So, you ready?
My lord.
My lord,
Today,
this matter
You
can
will
be.
be arguing.
My lord, Mr. Paul is on his way, my lord. Today, my lord, the learned AG has to reply to our submission, my lord, made on the last occasion, my lord.
Can be taken on any other date, Lordship.
Next week, okay.
My lord, there is an urgency in the matter, my lord.
Urgency, we can't help it. Even then, your case also becomes.
The government is trying to close down the CPF account, my lord. They are
trying to
pressing
close CPF
the
account?
government, my lord.
Now we'll have a post on Thursday. We'll take
My
it.
lord.
Yes, Mr. H. Karwanlang prays for some accommodation due to the unavailability of the then Advocate General. So, this is the matter on Thursday. Stop compilation of judgments be submitted to court master in the course of the day.
We have submitted.
Yes.
7.
7 is connected.
7 connected just together on Thursday.
8.
I oblige.
Yes, what about the alternate?
Yes.
The alternate route.
Just, I'm sorry, my lord. 5 minutes. I'm just 1 minute. Yes. My lord, on the last occasion they had filed the written submission, and in that they have annexed the notification which is September. Where is this?
Where is that?
Yes, my lord. Where is that? I'm sorry, just 1 minute. That, my lord, is Annexure 2, page 37.
Yes.
Now, there are two aspects in this, my lord. This notification is subsequent to, if your lordships remember, we filed a writ petition in I think May, and that was moved in 2024. Subsequently, an interim order was granted by this court, and the matter was finally heard in, I think, April 2025. Subsequent to that, my lord, my learned friend had come and produced this notification by saying that the tribunal is now being constituted and all matters needs to be transferred in terms of this notification, which is September. May I just read this notification, my lord? That's at Annexure 2, page 37. This is notification of GST Appellate Tribunal Appeals, deadline extended up to 30th of June, and standard 3 months limitation is applicable from 1st of April 2026. My lord, it says, in exercise of the powers conferred under subsection 1 of section 112 of the Central Goods and Service Tax Act 2017, the government, on the recommendation of the council, hereby notifies 30th of June 2026 as up to date of which an appeal may be filed before the appellate tribunal under this act in respect of all cases where orders sought to be appealed against is communicated to the person preferring the appeal before 1st of April 2026, and all appeals in respect of the order communicated on or after 1st of April 2026 may be filed before the appellate tribunal within 3 months from the date on which such order is communicated to the person preferring the appeal. So I qualify under these things to go the matter to be filed before this. However, my lord, this notification, according to me, does not take care of the circumstances of a case which is pending before this court. Now, these are cases where you are supposed to file the appeal. Does not necessarily say what happens.
We can transfer the matter.
So you can, lordships can transfer it. All I'm saying, my lord, in regards to that, there is a recent judgment in 2023 of Justice Dipankar Datta, where they have said, with the presence of an alternative remedy, does this completely ceases for the High Court to see it? It may not be. There are certain circumstances in like us, where matter has been filed, matter has been heard, and interim orders have been passed, my lord. So in that circumstances, it is also concluded. Now, the filing of an appeal, my lord, has two options. One is I will have to redo the entire exercise. There's a question of a pre-deposit also before the appeal. So there is some way that I'm also being penalized to a certain extent to go back to after doing the entire hearing. In that regard, my lord, I only want to show one judgment, my lord, which I'm passing it to your lordships. Only 2 paragraphs in this.
Yes, got it thoroughly. We all
Yes, only paragraph, my lord, that lordship said I'm sure has already gone to. Para number 8, my lord, is what I'm relying on in this judgment. Rest is can be lordships are already aware. That may I just read para 8. That apart, we may also usefully refer to the decisions of the court 1972 so and so in the state. What appears on a plain reading of the former decision is whether certain items fall within an entry of a
Mr. Fugan, the thing is that now, if it's a pure question of law, it will be dealt with difficulty.
Correct.
But the thing is that now, in your case, I think there are certain dispute questions of fact with regard to entries made in your books of sale,
Right.
Or whether the incidents of whatever you see very. So
the notebooks and notepads and all. Correct.
Those which you are relying upon.
Correct.
Yes. So whether you think that they just in common kacha purchase.
Correct.
It does not disclose really sale.
Correct.
But it's just a inventory or So those things now, whether the acceptability of those whatever you record,
right?
Now whether the red court can go into it and examine as to the exact veracity or whether we can rely upon them.
There's another point, my lord, which I have raised it in my written submissions, my lord. I have also said that in the writ petition, just 5 more minutes, my lord. I have said that in the writ petition. If your lordships will be kind enough to come to page 27, this is one of the.
You can satisfy the court.
Yes, because in terms of this judgment, my lord, the 3 grounds that they have laid down in under what circumstances the court can proceed with it. One of the grounds is this, page 27 of the writ petition. I have taken a specific allegation, my lord, which has also been argued on the last date. Page 27, para 24. Now, this, according to me, was a very important ground that we have taken in that, and your lordships has heard us on this point. Page 26, para 24 and 27 of the writ petition.
Page 26.
Yes, so page 26, para 24. So one of the grounds which are laid down in this judgment, my lord, falls under this. May I just read 24, my lord?
Yes.
The petitioner humbly begs to submit that the additional commissioner taxes so-and-so and an authorized superintendent to inspect and premises of the petitioner on basis of information received by an additional commissioner of taxes has suppressed the transaction relating to supply of goods and service and thereby have contravened and so and so. Subsequently, the same additional commissioner of taxes issued the notice for personal hearing for the appeal, and he himself conducted the personal hearing on so and so dates. Thereafter, the additional commissioner passed an impugn order on 26/4. It is to be stated that the petitioner has preferred the appeal through a GST portal so and so. Next line, but instead of providing the petitioner a faceless hearing, my lord, his hearing was conducted on order passed by the additional commissioner. One of the grounds which says, my lord, where a court can proceed, one of the reasons was also this. So your lordships may also keep in mind this issue before passing this order.
Yes. Yes. So you're saying natural justice?
Yes.
This is one of the grounds. Yes.
Correct.
But then if it's a mixed question of law and fact, so
one of the grounds would also be this, if there is a violation of this. So that is my humble submission. I have got my written submission, my lord, so I'll pass it on. Otherwise, your lordships, I leave it to your lordships based on that notification, whatever.
Yes, we'll give you enough time to go before the tribunal, the appellate tribunal. Yes. Yes, Mr. Sangha.
My lord, as far as this present case is concerned, my lord, there is no substantial question of law, my lord, that is involved. And moreover, the as per section 117, my lord, of the GST Act, my lord, there has to be a substantial question of law which has to be framed by the court, and only on those questions of law, my lord, the court has to hear the matter. It cannot go beyond substantial question of law, my lord, which has been framed by the court. Here, my lord, there is no such substantial question of law which has been framed.
Yes, another thing must have spoken that the n number of decisions, when especially Supreme Court is holding that revenue matters, not when there's a specialized forum, you know.
Both sides, in sales tax
sides.
matters also, in excise
Yes,
matters
yes.
also. Both sides, they have relied on that.
So you have to cover the exceptions.
Yes.
And they've been hammering Whirlpool, hammering all of these other decisions. So, you know.
In fact, all of them are already discussed and referred in this judgment also. But the only leverage that I would like to take is the fact that there is a situation like this as arises, where
Yes.
it is heard, argued, concluded.
There is a recent case from this court also where they on jurisdiction, correct? I mean, like saying they're questioning jurisdiction. That's why they say 2 to 6 will be attracted. But then even then, question jurisdiction also, if you know proper officer.
Territorial jurisdiction, yes, madam. That's right.
So
Territorial jurisdiction, yes.
We'll pass orders. Then.
Yes, I'm extremely grateful, madam.
Obliged.
I'll just pass on my written submissions, madam. There.
Third, judgment reserved. We'll pass on.
Obliged.
Extremely grateful, madam.
11.
Before Lordship, for humble request.
May please Lordship.
Yeah.
Lordship, kindly have Annex D, page 88.
Yes.
Lordship, after approval by the competent authority, written a letter to the Joint Secretary of the Government of Meghalaya, Excise, Registration, Taxation and Stamp Department for refund of excess amount.
Yes.
Lordship, now come to the page 90, paragraph 5.
Yes.
Lordship, the head of the account for debiting the refund of excess amount of tax paid under MVAT Act is 040 tax on sale, trade, etc. 1110 trade tax 05 deduct refund. Lordship, my refund has already been approved by the competent authority, and a competent authority has written a letter to the joint secretary for debited the amount. For debited the amount to 2024. Also, there has been 2-year lapse. They have not debited the amount.
Mr. Singh, we have only one slight problem here. The general is not present. We will post it on Thursday. You kindly be available. Yes.
May please Lordship. Lordship, as per the last order, we were supposed to file additional.
Where there is affidavit replace the records of proceedings for the authority.
Mala, I'm waiting for some more time for filing.
By Thursday.
Mala, I require some more time, Lordship. We haven't received the.
But then you waited for 2 years for the refund, correct? It's been 2 years. It's been 2 years since you paid for the refund, correct? This letter dated when? The page 88?
2024. 17th September 2024.
Yes. Anyway, then
Lordship,
after 1 week.
Lordship, please.
Mala, after 2 weeks.
Yes.
Lordship, please, I am failed to understand the modus operandi by my learned friend. They have caused the 1 crore to the state exchequer after filing the writ petition. Why they are not releasing my amount?
They are handicapped today because the Attorney General is not available. When will he be available? We'll fix it on. Today is the 14th.
14th allowed.
This is on 28th as a fixed matter.
Mala.
Yes. On the prayer of.
Lordship, please pass the traction to the respondent authority before that date. Release my amount, please.
So that will come on 28th. Yes. Let them file. Yes.
Please, Lordship. Please, Lordship.
Yes.
Thank you. Oblige, Lordship.
Yes.
Any mention?
My lord, 71.
What about
2
71?
weeks more, sir. 71, serial number 71.
Dismissal. No
What's the
objection.
matter about?
It's a dismissal of this.
Dismissal and honorable acquittal and acquitted. Those matter.
Okay, yes.
2 weeks, you'll be.
Obliged.
Highly obliged.
Yes, please, Your Lordship. Lordship, I beg to mention item number 66, Your Lordship. No objection, my lord.
Yeah, objection?
No objections.
Yes.
Much obliged, Lordship.
Please, Lordship. Lordship, I beg to mention item 68.
Who has for the petitioner?
No
Yeah, objection?
No objection.
2 weeks time, Lordship.
We are for whom?
For respondent number 6, Lordship.
What about the other correspondence?
1 to 5.
Yes. Yes, fine. Yes.
Lordship.
May I please, Your Lordship, I beg to mention item number 65, my Lordship. I'm praying for the time, my Lordship.
What's the matter about?
This is regarding the service matter, my Lordship.
Service matter?
Work
What?
charged
Service matter?
employee.
Work charged employee.
Work charged employee.
You want regularization?
He has been regularized, Lordship, but he wants regularization in the
Then this matter we
upgraded
can finish
post.
up. Where's Ms. Hazarika? Or Demo? We won't keep these small matters pending.
He is getting sick, my Lordship.
He's getting sick.
Yes, my Lordship.
Okay, yes. 2 weeks.
Obliged.
Highly obliged, Lordship.
Please, Your Lordship. Your Lordship, I beg to mention of item number 69.
Who's appearing? Mr. Day?
4 and 5. Respondent 4 and 5, Your
No
Lordship.
objection.
No, Your Lordship.
Very good, yes. Yes.
Much obliged.
Please, Your Lordship. I beg to mention item number 26, Lordship.
Number
26.
26. 26. Who's for, Yes,
No objection.
Refer to.
yes. You're for with Mr. Sen.
Yes, Your Lordship.
Yes, follow the list. Yes,
At the end of the other side, I beg to mention item number 23.
yes. Yes. Who's there? You're for whom?
Respondent number 1.
You're for number 1.
Yes, Your Lordship.
Were you look seeking time? Yes.
I am for respondent number 2.
Who's you asking for adjournment? Is he with you?
No, Your Lordship. I'm for the
You're for
petitioner.
whom?
For respondent number 1. Yes.
What do you want? What do you want? You want a matter to be heard or adjourned? What's wrong with him?
I'm on behalf of respondent number 2, item number 23.
What do you want? What's your prayer?
Time. We are
Time?
seeking time.
When you say that, yes?
No objections, Lordship.
Yes. Seriously shell shocked. Yes.
May I
Yes.
please, Your Lordship? Your Lordship, I beg to mention item number 21.
Where's Mr. Datta? Today we'll close the matter.
Your Lordship, he is not feeling well. That's why.
Yes.
I pray this matter may come up after 2 weeks, Your Lordship.
No, because he's just supposed to take some instructions.
Yes, Your Lordship. Your
The
Lordship,
matter
as
is
per.
very limited also.
Yes,
You
Your
have the
Lordship.
brief with you.
No, Your Lordship.
What is your name?
Pishala.
How many months you practice per year?
1 year, Your Lordship.
1 year, very good. You can argue next time. Okay, MSP Sharam, praise for Lord. We'll give you 1 week's time.
1 week, Your Lordship. 1 week, Your Lordship.
1 week.
2 weeks, Your Lordship, please.
They're objecting to it. Yes. Yes, we'll give it week then, yes. I'm expecting next date, no further adjournment will be taken, yes.
Your Lordship, they are connected matters to Your Lordship, 18, 19, 20.
Connected?
Yes, Your Lordship, to be taken up along with...
Similarly situated?
Yes, Your Lordship.
Your Lordship, this my cases are different from Mr. Datta's case, Your Lordship.
Different which way?
Different means they are, though they are temporary, they were conferred with temporary status, but they do not have eligibility criteria for regularization. So, Your Lordship, I have got one judgment. So
you're not eligible for
they are not eligible because 7-8. But Your Lordship, Your Lordship was pleased to pass one order, one judgment. So I'll place it
What
at
was
the
that judgment?
judgment in inverse. Your Lordship, it is in the file. Just a minute.
Yes, get it. What is that? But in orders, we'll take it up when it comes.
Yes, Your Lordship.
Yes, we'll call out. Yes.
One order. Yes.
Yes. Yes.
May it please Your Lordship, I beg to mention item number 28 to 64. Conducting counsel, Mr. Khalab is honorable, Your Lordship.
What is
in item number 28, we have filed our rejoinder to their affidavit.
No. What is for today? For hearing?
It is fixed for hearing.
Yes, Your
Yes,
Lordship.
then?
We have just received the rejoinder yesterday, Your Lordship, filed by the petitioner.
That means holds 28 to 60?
64, Your Lordship. They're all connected.
What to do?
No objection, Your Lordship.
When next week?
2 weeks, Your Lordship.
2 weeks?
Yes, Your Lordship.
Yes, as the conducting counsel for the respondents, Mr. Philip, is still to be unwell. Let the matter appear after 2 weeks. Yes.
I'm appearing for item 63, Your Lordship.
Very good. Recall Mr. Robin's name 62.
Obliged, Your Lordship.
Right.
Yeah.
May it please Your Lordship, I beg to mention item number 24. Your Lordship, I play for 2 weeks time. Item number 24.
Yes.
I pray for 2 weeks time, Your Lordship.
On whose behalf?
On behalf of Arkarsat, he is having some personal difficulties, Your Lordship.
This is too much. Get ready with the matter today.
They have informed us beforehand, my lord.
1 week, okay.
Obliged, Your Lordship.
Much obliged.
Your Lordship, I beg to mention item number 22.
22? Nothing is left now. On whose behalf? Whose
For
behalf?
respondent number 1, Lordship.
Who's number 1? Which lawyer is arguing this one?
R.K. Sundram. He's unwell, Your Lordship.
Yes, Mr. Dakhar.
Lordship, actually, we
Yeah,
are ready.
objection.
We're ready for the matter today, Lordship.
As my
But take up
seniors-
tomorrow.
They've not informed us, Lordship.
Can you give us 2
You
weeks
informed.
time?
You didn't take consent.
No, Lordship.
I didn't know, Lordship.
Yes?
I didn't know they were the party.
You didn't know that your counsel. Okay, now you know. Yes, 1 week. Okay.
Lordship.
Much obliged.
God bless.
May please, Lordship. Also, I beg to mention item number 70, Lordship.
Any matters left for mentioning?
I thought this is a contempt matter, Lordship, and it
Yeah,
is being
objection.
led by...
Yes, Your Lordship.
Then we'll call it out. Yes. Yes. Solve the list. You don't object, then if you object, then you won't adjourn it. Yes.
From supplementary list, item number 1.
May it please Your Lordship. Your
Yeah,
Lordship,
what
this
is
is a
this?
transfer petition, Lordship. But I would like to bring to Your Lordship's notice that Your Lordship has taken up this matter before as a counsel.
This matter?
Lordship.
Okay, yes. Please discuss this matter before any other bench without notice. Next.
Highly obliged.
Yes, Mr. Punna.
May I please, this contempt application for not complying with the order of this honorable court.
Where the
The case relates to non-release of the petitioner's substance allowances. Following the order of this honorable court, of course, it has been released for one time. Page 8, my lord.
Meaning they have released. They have
One
released
time,
it.
yes. At one point in time, they had released and then again stopped. Page 8.
Now what's happened to the? Is there department proceedings pending against you?
No departmental. There is a
suspended since when?
Suspended in the month of March 2025. Pending there's a criminal case against the petitioner with allegations of.
Yes. Since when you have not been paid a substance allowance?
I have received on 26/3/2026 for the month for 9 months with effect from the month of June 2025.
23/6 you received.
Yes.
And how can a contempt maintain right now? Now only in July.
Then from the month of March 2026 till date I haven't received. Whereas on being inquired from my colleagues, they are receiving their salary regularly on the same sanction.
Where is this from, this case?
West Garo Hill.
I don't know whether contempt will be entertainable at this stage. Anyway, I heard Mr. Assumption issue notice returnable in 2 weeks, separately taken to the period, this and so on.
Free.
The petitioner is aggrieved with the non-payment of his back wages from the year 2008 till 2018, my lord. And
Back is working as what?
he was working as a chowkidar and subsequently he was promoted as peon. But what happened, my lord, in this matter, my lord, the petitioner was suspended in connection with a criminal case, my lord. Subsequently, he was reinstated, my lord. He was acquitted and then he was reinstated. And then,
So
my
for
lord,
a period of suspension,
it has been regularized, my lord. It has been regularized. My lord. My lord, may kindly see annexure 15, page 46, my lord.
Yes.
In pursuant to the court order dated so-and-so, acquitting Sri so-and-so, ex-chowkidar Milliams ICDS project presently
Didn't pay you for which the period?
from 28/11/2008 till 31st.
You accept
Then-
notice, Mr. Sinkan? Mr. N. Sinkan, Learned Counsel is present, except we have all the respondents who put a notice required just after 2 weeks for instruction affidavit. Yes. Yes.
4.
Please, Your Lordship. This
Yes.
matter is with regard to retirement benefit, Your Lordship.
MTC?
Yes, Your Lordship.
I will 10 days time.
Yes. Third, MS Kamendai, also issue notice. Ms. M.U. Ahmed, present, except on behalf of sole respondent. Done this after 10 days for instructions affidavit.
5.
May please, Your Lordship. Lordship, this is just a direction that we had filed a representation before the executive magistrate NOPO for not issuing any legal hair certificate to the respondent number 5. Legal hair certificate. So what happened is that we have they had the respondent number 5.
To whom? To whom? To issue not issue to whom?
To respondent number 5.
Who is respondent number 5?
Respondent number 5 is niece of the deceased, my father's deceased.
You are who are you?
I'm the son of the deceased, Reverend.
Son of deceased, and the respondent number 5
is the
seeking a
niece.
legal heirship certificate.
Yes. So what happened is that, Your Lordship, is that I am the son of Reverend Gerson Lingdo with Otis, and my mother is Otis Walang. So in 2004 October, I have been baptized and recorded all the certificate. The name of my father, the name of the father is yes, I am, yes.
Or you adopted?
Yes, it's we said it's adopted or non-biological father, but that is not clear till date.
But
Because-
it was any we adopted just informally or the formal adoption?
No, we that's the ground of adoption. We didn't know anything.
You appear in private respondent?
No, Your Lordship. For respondent number 124, Your Lordship. Still.
Still.
So the respondent number 5, he said, is the niece.
Yes, the niece of
She's
the.
applied for legal heirship.
Yes, she
Granted.
applied for to get the legal heir certificate from the executive magistrate. No.
Then why are you here now?
Your
Has she been granted the?
no.
Then why are you here right
We are apprehend that maybe the executive magistrate will issue a legal heirs to
Then
the
if they issue,
respondent.
then that at that point of time when you come, now how can you? If the matter is seized by the executive magistrate.
No, we had filed an objection, but till now they did not dispose of, did not hear any.
So what direction is seeking now?
The direction is that
Is it not the issue or that the matter be disposed of by the executive magistrate?
the direction that the executive magistrate.
Let's see your prayer.
Yes, I will come to a prayer.
I don't really understand.
Issue-
Why you agree? The matter is still there. You put in objections. They'll pass orders.
Issue of writ in nature of the mandamus or
Properly here,
yes,
evaluate partisan order. They expected to do that.
that's only to direction that the representation
Why
dated.
apprehending that you're not being given a fair hearing?
No, Lordship.
How do you apprehend that? Have you
We-
made any
we are
arrangements here?
I will take you, your Lordship, to page number 19, and type copy is page number 20.
Yes.
So in the last paragraph, your Lordship, last two paragraph, in the interest of proper adjudication and afford opportunity to all concerned, the said claimant are hereby directed to appear before the court on 30th April 2026 at 2 p.m. and produce documentary evidence if any in support of their claim.
Claimant means you.
No, the other side.
Okay, then what happened after that?
Yeah, and on 5th May 2026, next order. This one also is done. Mr. Bloomberg, if I take you to
You
your
are the
Lordship,
applicant. Who applied legal aid?
the respondent number 5.
And then who? When you say both applicant and claimant along with counsel, you said claimant is them. Then
Yes,
who's?
yes, the claimant is respondent number 5. I am the petitioner and I am the objection. I object.
No, please listen, Mr. Khalindo. See the order. You say that you're the claimant.
No, I am the claimant that after I filed the objection, I claim that I am the legal heir of the deceased Reverend.
Fine.
Joseph.
Now say both applicant and claimant. You say applicants them and then the claimants for them. Then counsel. John please file Mr. Bloomberg so. Who is Mr. Bloomberg Walang?
Bloomberg, I am the petitioner.
Then you're the claimant here.
Yes.
Then you submitted documentary evidence.
Yes, we have submitted everything. Yeah, Your
So
Lordship,
what happened
I'll take to page number 23. All this.
No, what order was passed on 3rd June?
No, they have not passed anything.
Then what orders you want from this court?
We are apprehended that they.
How will you file? Have you seek injunction from this court? That not to pass legal action.
No, our prayer is very limited, Your Lordship. That our petition 8 May 2026 and 26 June.
See, Mr. Khalindo, this is a very misconceived petition. Here's what you have to say.
Yes, Lordship. Lordship, it was fixed for hearing on the 3rd June, Your Lordship.
What happened 3rd June?
No, they have seeking adjournment.
So where's that order on 3rd June that they will adjourn the matter?
We didn't.
Then take down heard Mr. Kiwi Harlindo, counsel petitioner, MS ADCM is present on behalf of respondents 1 to 4. No notice deemed necessary to respondent number 5. It appears from the submissions and from the materials placed that the petitioner is seeking directions that the executive magistrate Respondent number 3 of Riboy District Nongpo afford the writ petitioner a fair hearing in legal airship case number 2 of 2026, which is pending adjudication. Though the learned counsel petitioner has attempted to make out grounds to warrant interference, this court in a custody of this court, the writ petition is premature as the matter is still seized by the concerned court. Or what do you call it, authority. So, in this view, the matter at this stage of petition is not entertained. So, needless to add, in any forum, it is expected that adequate opportunity is granted to parties who appear before it. So, matter stands disposed of it.
Highly obliged.
6.
May I please, Your Lordship?
Yes.
Lordship, may I have this matter at the end of the board, my lord? The arguing counsel, Mr. Andy Shula, is on legs before the Honorable Division Bench, Lordship.
After some time.
I do acknowledge.
Daily less item number 1.
Yes, my lord. My lord, I had filed a application for recalling an order, my lord.
What order?
Lordship, this application is earlier.
I filed it this morning, my lord, yes.
Recalling what order?
My lord, recalling an order that did not give me liberty to file fresh, my lord. Order dated 7/5/2026.
Order dated?
7/5/2026, my lord. In Miss Case number 123 of 2026.
Miss Case 123?
Yes, my lord.
Disposed of?
Yes, my lord. My lord, here, my lord, there were certain defects on my application. So I withdrew the application, my lord. But then, my lord, I inadvertently missed to seek permission to file, liberty to file fresh.
Lordship, may I submit, my lord? This order, Lordship, may I just submit, Lordship?
There were certain defects, my lord.
Now this para 2, it says that earlier she has withdrawn because there was some defect in the application. Now again she is filing this application to record that order, which means to allow again that defective order. And in her prayer, she have never stated in para 2, para 6, and in the prayer, she has just.
The Miss Case filed today?
Yes.
It's not before the court.
Then, my lord, will list it tomorrow, my lord. Let it come before the court.
Since he is making submission, that's why I'm replying to.
Yeah, my lord, will list it tomorrow.
MS OAI Bank submits that Minister's application has been filed, praying for recall of an order dated
7/5, my lord.
7/5/2026.
Yes, my lord.
Passed in Mrs. application number
123, my lord.
123 of 2026. As the same is not yet before the court, let's say after tomorrow, for further orders.
Most obliged.
2.
Much praise, Lordship.
Yes.
My lord, I'm seeking some more time to file our Miss Case, my lord, in order
Miss
to
Case?
impeach. Yes, my lord.
Lordship, petitioner was to implead the first wife and take steps on her.
Why no one appeared last time?
I was on legs, my lord, another court.
Yes, Emma Marak prays funds allowed for the 1 week's time to find appropriate application for impleadment.
3.
May it pleases, my lord. My lord, all parties have filed their affidavits. My lord, if my lord would have 5 minutes of your time, my lord, I'll convince your lordship the case can be disposed of the day itself.
Now, today?
My lord.
Ready?
Based on the records on...
What's the matter about?
Family pension, my lord. I'm clear. I'm the
It's a
wife.
death certificate, Your Lordship. With regard to death certificate.
Who? Yes, what do you want?
Who's for private respondent, madam? Private respondent. Respondent number 6. 5 and 6.
Yes, what do you want?
5 and 6. I think it is represent only for respondent number 6. 5.
Who?
This called mean death certificate was issued in
6
her
only,
name.
7th EB Pasa.
Yes.
7th EB Pasa. 5 is whom? Farnaki. What is?
5 they have read him as by name, so I cannot represent his is in the engineer.
Also represented by the same council, my lord.
By numbers. What's your name? No, your title. What's your name?
Sir, my lord, my name is Preeti Parvat.
Prabhat. P. Prabhat. Who's your arguing counsel? Who's arguing counsel you say for this?
ED Sharma,
I will say.
Madam ED Sharma.
Who's ED Sharma?
Lord, she's predominantly in the trial court, madam.
When did you file the affidavit, Mr. Ibrahim?
I filed it
18/6.
18/6. Yes, sir. Though Mr. Missile admits that the matter can be disposed of today itself and no rejoinders will be necessary. But, however, prayers made on behalf of respondent 5 and 6. Some accommodation due to absence of the arguing counsel just after 1 week. Yes. File.
Lordship, no, Lordship, I have yet to receive the.
See, what is this? He said within 1 week it filed. It was 18/6. Now we are on. This is 14.
Lordship, I'm praying for another week, Lordship.
You pay cost.
Lordship.
Then do give undertaking to the court if you can't file it.
Apologize, Lordship.
Yes, Mr. Sheikh.
I have filed it.
Yes.
My lords, I have gone through the.
No rejoinder necessary.
No rejoinder
Yes,
necessary.
as long as she submits that no rejoinder will be necessary to the affidavit filed by 1 and 3. Stop next line. Next para MSB Pasa submits that due to unavoidable circumstances, the affidavit could be filed within 1 week. She prays for further.
Definitely, Lordship.
2 weeks. Further, how much time you want?
2 weeks, Lordship.
2 weeks. Praise allowed. Yes.
Oblige me.
5.
Well, the pleadings are complete in this case, my lord.
Yes.
My lord, may I pray that let this matter be come up for admission hearing?
You're not filing rejoinder?
We have filed the rejoinder also.
Yes, Mr. H. Das, counsel for the petitioner. Submit the plea complete. Upon this matter for hearing, you take a day. Yes, on so and so.
Admission hearing, my lord?
Admission hearing? Today?
No, my lord. The next date.
Okay, let's for admission hearing.
6.
Please, Your Lordship. Your Lordship, I'm seeking for time to seek instructions, Your Lordship.
What instructions?
Lordship, since the report of the
as per last order, all these sort instructions. What instructions?
whether we'll be withdrawing the petition or not, Your Lordship, since the report of the public hearing has come out.
What is the report?
Your Lordship,
what does the public hearing say? No objection.
Public hearing is yes, my lord.
Project is feasible.
So then it's fluctuous. Where's your prayer? Let's see.
So even the prayer is not for.
No point keeping this. This clogs the list. Quashing and setting aside public hearing conducted on 23/9. That's gone. Directing that to conduct fresh public hearing. Have you challenged the inquiry finding? Public hearing findings?
Just came out.
Yes, Mr. Yes.
Subsequently, only just came out.
Then you draw it.
Just take instructions, Your Lordship. A week's time.
What instructions will you take? Material instructions?
Yes, Your Lordship.
Prayer 4, Lordship. Kindly say prayer 4 also. Now they are in possession of the UIA.
They have it also.
They are.
Then?
A week's time, Your Lordship.
Direct response. We already gave you time since last month.
We'll just examine the.
Same prayer making
we'll
now.
just examine the procedure in which the.
You already had enough time to examine.
Yes, Lordship. Just a week's time, Your Lordship.
You're going to examine or re-examination?
Re-examine.
Just a week's time to seek instructions for it to withdraw now.
They will have to challenge the report, my lord, if they are
That's
at all
the report,
agree.
yes. Though Mr. Pasanti has prayed that we allow further time to obtain instructions. Instructions submitted and Syncon submitted that the public hearing has since been conducted and the report has also been generated. But the same is also concurred to by Ms. Emil Nongpur, who submits that nothing remains consideration repetition, and if any fresh cause of action has arisen. Yes. Including submissions, this court sees a few times to allow the petition to obtain further instruction, matters was closed and disposed of, with liberty to file a fresh on a fresh cause of action.
Okay.
7.
Yes, we're praying for some time, Lordship, for rejoinder, Lordship.
How many times you pray?
This is the second time, Lordship.
Second time? Will it be the third time now?
No, second time now, Lordship.
Yes. For number 1, it didn't, no need for affidavit. Yes. Mr. B. Snaitang prays for. Is allowed for the 2 weeks time.
8.
For affidavit. List on so. Yes.
Please, Your Lordship, I'm for the petitioner.
Yes.
Please, Your Lordship, I'm praying for
Lordship.
Yes.
to file an affidavit, Lordship. I'm praying for
A
some
fresh matter.
Lordship.
Yes, sir. As prayed for the 3 weeks time allowed by affidavit. Yes, thereafter also.
9.
God bless.
Yes. Contempt. What do you do contempt now? File the affidavit.
They haven't filed anything yet, I think.
Okay, file.
They've not filed
Has
anything.
been filed.
We're praying for some more time, my lords, for the affidavit.
When's the matter coming up?
I requested for 6th of August, my lord, if it is not inconvenience.
Can be fixed on the same day.
Yes, we'll fix on the same day. Mr. S. Pandey prays for allowed further time to file the objection. So, yes, on 6th August.
Should be grateful.
10.
My lord, if this petition can be disposed of today, Lordship.
Kandokar.
Yes. In view of the affidavit filed by the personal department, that is at para 5, 9 and para 5, 10 and 12, Lordship.
Let us see that.
Yes,
Para
sir.
5.
Para 5.
Five.
Number 5.
No, Your Lordship.
This is
Respondent
2.
number 2.
The personal, because the, that
Secretary to the Government of Meghalaya has
only
filed
for
this
regularization was left, Lordship. That is why that pension was not processed. Now,
no, there are 2 affidavits here.
To one affidavit is
one is filed by the
respondent-
administrative department, Lordship.
Respondent number 5.
Moment.
Thangsang Mamin is respondent number 2.
Yes, yes,
Secretary to
Lordship.
the Government.
This is the
Yes,
main
sir.
affidavit.
This one is the main affidavit, Your Lordship.
Paragraph number
5, Your Lordship.
5,
my lord, 10,
10
and 12.
and 12.
9 also.
Because the
9 also.
Mr.
9 also.
9, 10, 9 is
S.E. Sheikh
Approved by the
at
Cabinet
outset
regularization.
has submitted that in view of the affidavit filed by the
That's one or two.
respondent number 2, Secretary to
Personal
To the Government of
Secretary to Government of Meghalaya Personnel and
Government of Meghalaya.
Administrative
Personal.
Reforms B Department, the matter can be closed now. MSS Baras Haji Leonard GA has also submitted that the cabinet in its meeting held on 30th June
30th
was
June.
pleased to approve the proposal for regulation, and that the same has been reflected in the affidavit, as we stated in the affidavit. Accordingly, Nakpara, in view of the submissions of parties and the affidavit filed by the respondent number 2, nothing remains for consideration and the petition is closed and disposed of it.
My lord, some time frame may be given so that
Yes, expected that the entire exercise for ratification be completed within a period of 4 months.
3 months, let it
4
be 3
months.
months.
Yes, sir.
4 months, fine.
4 months. Much obliged.
Much.
11.
Preferably within 4 months.
My lord, I'll be filing my rejoinder, my lord, in a week's time.
Is this that matter regarding social welfare?
Hostel,
Yes,
yes, my
Lordship.
lord. I'll
How
file
many
it.
respondents are there?
in a week's
Any
time.
other private respondents?
No, my lord.
Only state respondents?
State.
What do you want to file today, Mr.
I'll file my rejoinder.
Rejoinder?
Yes.
Mr. N. Sinkwan submits a rejoinder to be filed in the course of the day. This is the matter for hearing.
My lord, I'll be filing my rejoinder in a week's time, my lord. So.
On a week's time, yes, this thereafter. This on after 2 weeks for further orders.
My,
12.
May please your lordship, we'll file a rejoinder after the all the respondent filed affidavit.
We've not received, my lord.
5 is? Who's 5? Yeah. You file the affidavit. Then you say you file rejoinder number 5. You do not file affidavit. What rejoinder?
No, we have not received.
Just now you made a submission that I want to file rejoinder too.
No, we will file a rejoinder after receive all the after the respondent filed their objection.
1.
So we will place all.
2. You already filed the affidavit. 3 and 4.
4 and 6, my lord.
3, 4 and?
No, 4 and 6. 3, 4 and 6.
3 and 4.
We've already filed, my lord. 3 and 4 only.
3 and 4.
Even for 6 we have filed.
5. You'll file course of the day. Course of the day. Yes, MS PS Congress for 5 days for 2 weeks time to file affidavit stuff. The other affidavits, all the response already on board.
My lord.
Next paragraph, Mr. KV Karlinga. Please submits that you praise that allowed to file a rejoinder after all affidavits are received. Yes. Praise of this after 2 weeks. Yes.
Much obliged, my lord.
13.
For further orders. Yes.
May it please your lordship. Your lordship, I have already filed the reply to the status report filed by respondent.
What status report is this?
This is with regard to the land, your lordship, where they have made the land through my, where they have made the road through my land, your lordship.
In fact, my lord.
Yes.
The issues involved here, my lord, is all disputed question of facts, my lord, which is not maintainable, my lord. My lord, if I come to the prayer of the repetition, my lord. Page number 8.
No, sir, a serious report. I really constructed any road into the middle of my land.
Lord, 80% when they have filed the writ petition, lordship, the work was nearing completion, lordship.
Through her land?
Not
Yes,
through her land.
Lord.
The land, that road already existed, lordship.
Through my land, your lordship.
Yes, that land,
Village land.
a village road, that is already existed, lordship. This is not a new road.
Yes.
This is not a new road, lordship. Road has already been existed. Now
What's
it,
your objection? Where is it?
We objected that because they have made the road
let's
through
see
my land,
affidavit.
your lordship. Because from the status report, your lordship, they said that the land is to be made along, the road is to be made alongside my land, your lordship. But they have made through my land, your lordship. That's why. And there's no land survey, no demarcation, no nothing, your lordship, without any permission
You're through
from
your homestead land, where you're residing.
Yes, your lordship. Paddy field also
Paddy
is
field.
there, also, your lordship, through my paddy field also.
There are 2 status reports.
One
One is by
from the
By the
police station, your
BDO, my
lordship.
lord. One by the BDO and one by the police department, my lord. Because there are some allegations against the police, my lord, that they were forced to compromise. But in fact, my lord, as per the state's report, they had compromised outside the police station, my lord.
Oh, yes.
It's a government scheme, lordship. I cannot install the project.
20 years it has been used. Isn't here the report? 20 years. It's made under MG and areas.
The improvement is being done under that.
Now, where's the statement that there was no amicable settlement?
Your Lordship, we were forced to compromise,
Where
Your Lordship. In our writ petition, Your Lordship, we have stated that we
Where's the objection? You said you find affidavit.
Yes, Your Lordship.
Yes, where's that? Rejoinder.
I filed, yes, Your Lordship. I filed on 7.
Yeah, let's see what you say here. This is difficult also to. Where's the senior?
He's not here, Your Lordship, for
You
today.
can see that. He's not here.
Your Lordship, let it come up for hearing then, Your Lordship.
In fact, what will be filing the
What
objections
happened now?
now?
Hearing road's already done.
And they did not raise any objection, Lordship, at the initial stage. Now, if they have any issue, they can go to the civil court, Lordship.
Yes.
Civil court. Now, this is a government project, they cannot.
In fact, my lord, no complaint was made to the video at the point of time when the allegations was made.
MSA Kramandai submits that affidavit has been filed and objection been filed under has been filed to the status report submitted by the respondents. If the matter be, it's in orders, it's an admission hearing. After 1 week, yes, we close it.
Much obliged, Your Lordship.
Just matter 1 week. Yes.
14.
We are allowed. It's at 1 week. Yes.
I'm praying for 2 weeks.
Yes, 7 me no affidavit. Yes. What's the matter about?
This one actually I was regularized to the higher post. Now they have demoted. Saying
Demoted you from where?
From the section assistant from the Lordship. Then
from
Lordship.
You already retired?
Retired, my lord.
Yes. You getting pension?
No, not getting.
Why are you filing affidavit which does a pension matter?
No, I'm praying for 2 weeks. I'll file.
Praying is different thing, but 3 months have gone. We've been seeking time repeatedly. You must have given but surgery today again has made another prayer for further time to file affidavit stuff. Next time is allowed. Expected next date that the affidavit should be on board. Yes. Have you received instructions?
Yes.
So what does the instruction say?
The instruction is not clear actually. This way.
Yes.
All is well.
Much less.
15.
Yes.
May I please, Your Lordship? Your Lordship, I'm praying for some more time, Your Lordship, to file my affidavit.
Yes.
Lordship, with regard to respondent number 5 and 6, I file affidavit of service, Lordship.
You file?
Yes,
been
Lordship.
served?
Yes, Lordship.
I'm praying for some more time, Your Lordship.
Once again, let's see the affidavit. An affidavit indicating service upon respondents number 5 and 6 has been filed by the petitioner. So, accordingly, notice complete all the respondents. Yes.
I'm praying for some more time, Your Lordship.
You file, you already filed.
No, Your Lordship.
Ms. Ailingwa for
1, 2, and 3, Your Lordship.
1, 2, and 3. EB Prasad for
4, Lordship.
For the 2 weeks time for affidavit. This after 2 weeks for affidavits and for the appearance of respondents 5 and 6.
Much obliged.
16.
Yes. Inside.
May it please your lordship. Your lordship, I'm praying for some time, your lordship, in this matter to file my affidavit.
Last time you made a submission.
Yes, your lordship, we've received instructions.
Receive inputs.
Instructions we've received. It's
What
still
does it say?
pending with KHDC, your lordship. Your lordship, because this involves clan. Because you want to change. Much obliged, lordship.
17.
The person wants to delete his
Yes, your lordship,
surname.
he wants to remove his surname.
Yes.
Wait, please, my lords. Where's the letter? Let's. We have received a communication from the MACL. Let's. They say. Give my note, please.
Order pass. She can share that.
Copy.
Yes.
Now, what they've agreed to is, Millets, they say that you make payment of 4 installments, Millets. The total amount, they say that you make it in payment of 4 installments, 4 equal installments.
You're agreeable to this?
We are agreeable to that, Millets. My instructions are very
Which is a
specific.
part of the order of the court.
Millets, I have only one difficulty over here. Now, if your lordships come to 1.
At first you say we agree.
No, 4 installments, I'm okay with it, Millets.
Then?
Because they have broken down that 4 installments into various parts, Millets. That's what I'm coming to.
Yes.
Millets, they say that the upfront payment of rupees 180, 1 crore 80 millets towards the first installment would be paid by you immediately, and thereafter power would be reconnected. That is where the difficulty lies, Millets. We had come before your lordships with a very specific plea, Millets, that we are in some financial crunch, which is why, Millets, we are not in a position. So what we are proposing to do, Millets, we agree to the 4 installments, we pay off the entire amount in 4 installments. We are only saying, Millets,
connect now.
No, we are saying that the first tranche, the first tranche of this payment, Millets, we will make an upfront payment of 50 lakhs. And Millets, the balance would be 1 crore 30 lakhs. That would be paid as the first installment only, Millets. But that would be paid on the date of the installment, and on upfront payment of 50 lakhs, Millets, let them reconnect. That's my only limited prayer. It is 4 installments.
These are my instructions. My instructions are in writing, before your lordship.
Millets, I'm not saying anything, Millets. That is why we are before your lordships, Millets. There is some genuine difficulty, Millets. We agree to the fact that they are saying, Millets, that the payment has to be made in 4 installments. We are okay with that.
Many months, many years ago, maybe the Ganesh matter, I said, don't make this court a bargaining
table, Millets. I am not here.
No question of any law being decided, any.
Millets, I am only saying. Millets, I am only saying your lordships is also a court of equity, Millets. Millets, I am only saying I am willing to pay in 4 installments. I do not
grow up front.
Millets, if they had that money, we would not be before your lordships. Millets, we are agreeing that it has to be 4 installments only. I am saying that the first installment be divided into 2 tranches. First tranche of 50 lakhs, Millets, we pay it within the next 3 days. Let them reconnect, Millets, and then we have to make them.
Half of this first tranche.
180 would be, Millets.
90 lakhs.
Millets, I can obtain instructions right away. Lordships, just bear with me for a second. Let's obtain instructions.
There has to be give and take. Yes.
Let's just all give. There is nothing to take.
Because the thing
only
is
for you to give.
It is only give, Millets. There is nothing to take. Millets, I am agreeing to everything because on this payment also, Millets, they will charge me DPC. That also I have to pay, and rightly so, Millets. I am in default. I'll have to pay.
Not let it not be that again you turn around and then you
I can't, Millets. Your lordships are making it part of the order. Millets, openly expressing before your lordship, Millets, there's difficulty. If there's no difficulty, Millets, we would have been very happy to pay it, Millets, and get it. I have to pay it in any case. I'm only saying, Millets, that the first installment be divided into two equal tranches.
Mr. Pandey, here are submissions.
I would submit that the petitioner, Millets, in the very first place has no right, no legal right, Millets.
That you don't need to submit, yes. It's just
it's like sort of considering the situation, Millets, they are willing to make the payment. Some Millets adjustment has been made and they have been allowed now Millets to make a payment in 4 installments. Millets, now if they are not agreeable to that, then
you can't pay the first installment. How do you pay the subsequent installments?
Millets, what has happened is the stock is inside the furnace or the silo as they call it, my lords. That's what my instructions are. If it is reconnected, my lords, that entire stock comes out. We can sell it off, my lords, and we would be in a position to pay off the entire.
Manufacturing cement.
Cement, my lords. That is the only reason.
But cement's a hot selling item now.
I am not aware, my lords.
Are you aware? Yes.
Well, it's all the more reason, my lords, that they allow us to withdraw the, my lords, get the stock out so that we can
When
make
was
the
the,
payments.
when was the disconnected?
16th, my lords. 16th
of July. Of June.
June.
So your plant is closed.
Yes, my lords.
Yes. Take down. Letter. Communication dated 10 July 2026 has been produced before the court today by the Senior Counsel, wherein the respondents have considered the prayer of the petitioner for clearing the outstanding dues amounting to 7 crores 20 lakhs 93,893 only, to be paid in 4 equal installments as per the terms and conditions which are contained in the said communication. So, next para Mr. K. Paul, as a counsel, submits that the petitioners are agreeable to the payment of the outstanding dues in 4 installments, but however, with regard to the first installment, as the power is yet to be reconnected, he prays that they be allowed to make an upfront payment of 50 lakhs and the power be reconnected, and the remaining amount, balance amount of the first installment will be paid.
1 crore 30 lakhs.
1 crore 30 lakhs approximately will be paid when the
installment is due.
When installment is due. So, next, Mr. A.S. Pandey, appearing for the respondent, submitted that the corporation has already liberally
decided that
liberally considered the prayer of the writ petitioner, and it is on this consideration that they have agreed to payment 4 installments. He further submits that as he has no further instructions, he objects to the prayer made by the Senior Counsel. So, next paragraph. This court, on examining the communication dated 10 July 2026 and also considering submissions made, though that there is nothing to adjudicate in the matter as to whether the prayer of the writ petitioner has been tenable, in the circumstances, however, on the undertaking given by the Senior Counsel, along with the he is the managing director.
Malas, on instructions of the managing director who is personally present.
Because the difficulty is the petitioner is they has a history of default.
Yes.
So the corporation in no given circumstance can accept these undertakings. They have to comply with
the undertaking is not to the corporation, Millet. My friend is a little mistaken.
The
undertaking is to the court, and I don't think the corporation is above the court.
Yes, undertaking will give to the court. Then we'll hold him for contempt.
Yes.
So Milots may then allow me some time, because Milots, this is I will file
tomorrow.
File an affidavit, then Milots.
Then just take the first paragraph, communication for installments. Stop the prayer of Mr. K. Paul record. Mr. S. Pandey prays now to obtain instructions on this new prayer of the petitioner list.
Yes.
Tomorrow.
Well, it's only tomorrow, Millets. Only thing, Millets, whether my lords would require the managing director to be personally present before your lordship.
Yes, tomorrow, yes.
Lordship. Yes, let his personal presence be recorded in so far as this is concerned.
18.
Because they are also saying, Millets, in this letter that you give us 4 checks on the date of the when the installment is due. So what I'll have to do is, Millets, if I pay 50 lakhs now, 1 lakh 30, I'll have to give them a check also. It is only on then that they're going to reconnect. So they're binding me from all, and other than that, I am before your lordships, and your lordships, I am also saying your lordships keep this matter alive.
We understand your difficulties and what we have seen, with the petitioner. I mean, n number of litigation with regard to
n number of litigation.
But if in my defense I can only say this, and I don't think my learned friend will be able to object to this.
I don't think it's
there was a view of
the business model adopted by the petitioner is really.
Only thing I'll
or very efficient.
I'll only say this. Your lordships, we were in due of above 25 crores. That entire amount has been paid. The fact of the remains.
Anyway, that's next matter.
18.
Not fall to due in the first place.
I'm sorry, Millet.
They should not fall to due in the first place such a huge amount.
Yes. Well, it's business, your lordships, it does not work like that. That's the only difficulty. Right.
Yes.
May I please, your lordship? 18, 19 and 20. Can it? Nehu.
Yes.
So your lordship was pleased to identical cases passed.
Now you're on Group C or Group D service?
Your lordship, because we got our conferment of temporary status with effect from 1993.
You are Group D service.
But your lordship, as per the
their temporary status casual workers.
Casual
they have been
workers.
conferred with temporary status, not against any vacancy. They are just casual workers, not against any post. Now, under the scheme, my lord, there is a provision which say once the temporary status is granted and they completed 2 years, they can be regularized against any Group D post, vacant post. Now, in the meantime, what happened, my lord? Group D post has been abolished.
Yes.
Right. Now, the Group C post is there. Now, we have written these cases, my lord, like other cases, to the UGC. Because of the change situation.
UGC can't do anything, can't extend the scheme.
Yes.
So that is a given. Where the Ilis Marbanyang, but they're not here to.
But your lordship,
that has been adjourned.
But your lordship was pleased to identify because they are also long years, so they have put in 30 to 30 years of service without break-in service, and that scheme is already over because it has been given effect only.
The scheme's over.
No scheme.
They're not getting relief under the UGC.
No, your lordship, I am not on this scheme because in 2018, by the order of this honorable court, they were conferred with the temporary status with effect from 10/9/1993. 10/9/1993. But the document which they have attached to the document, 98 document is there that they are entitled when the vacancy arises, they can be temporary.
What do you want now?
Now I may be allowed to, sir, your lordship, I may be allowed to file rejoinder in this.
They don't file rejoinder, but you're asking promotion. Can you claim for promotion?
Yes, your lordship, because the document is 98 document, 2098 document, 1998. Because when there is vacancy, but yes, for your judgment.
When was it filed, Mr. Sen?
Affidavit when you filed?
Affidavit this year only, your lordship.
This year only?
No.
Last year 25 November before.
You're not filed rejoinder till now?
Till now, your lordship, because I was on leave.
Posted for hearing?
No, yes, your lordship, without rejoinder, it is not possible at all.
Meanwhile, you listen to the order.
No, only 3 weeks time may be given because 3 rejoinder is required. Identical cases, and your lordship was pleased to pass on order. Your lordship may kindly have a look, your lordship, because almost they are also praying for regularization, all casual laborers.
What does it say?
Para 10, your lordship may kindly come to para 10. Para 10, how many vacancies are there? Because as per this letter, 98 letter, if the university needs additional posts, they could.
You file rejoinder then?
Yes, your lordship.
They don't file rejoinder, Mrs.
Yes,
Sen? Yes, MS Barasaji praised out of file rejoinder to affidavit filed by the respondent Nehu. Submit the delay in making the prayers due to the fact that he was.
Not only that, your lordship, this EGC letter, your lordship, doesn't contain any date also. Nothing. Addressed to whom?
Due to circumstances beyond our control. When this after 3 weeks. Yes.
Much obliged.
19.
3 weeks kindly may be granted.
19 same order.
19, 20.
90/20 connected matters.
Yes.
Second call from supplementary list, item number 6.
Where's Mr. N.D. Shulai?
Your Lordship, we have to inform them. Even
Yes, MSI. From now
Your Lordship, Mr. Shulai is on legs, Your Lordship.
Where?
He was in court number 1. He's waiting for the single bench, Your Lordship. The division bench has just risen.
Yes, Mr. Goenka. Welcome to General. We'll hear you.
yes, Your Lordship.
Please, Your Lordship.
What instruction do you have?
My Lord, as per the last, my Lord, as per the last order, Lordship, if I can take Your Lordship to the last order, Lordship, we had made objections with regards to the validity of the registration certificate of the society. Lordship, as per the last thing, as per the next year one, Lordship, the society had expired on 21st/7/2016. And if I can take Your Lordship, 21st July 2016, my Lord.
Yes, Mr. Haruna.
Yes,
what
my
happened? It expired, registration.
It's expired, Lord.
All Meghalaya contractors and supply association
My Lord, that
registered anymore.
Yes, my Lord. That you can see at I can take Your Lordship to page number 13, Lordship, of the petition. It expired on 21st July 2016.
30.
2016, my Lord.
Page 30.
13, 13.
13. I hereby certify so and so. Why 2016?
My Lord.
Then what happened after that?
Lordship.
So it's not a valid registration, Mr. Jindal.
No, Lordship, it was done. I have filed the.
If I can may I continue? Yes. Then, my Lordship, the petitioners had filed an additional affidavit, bringing on record the registration of the thing. My Lord, if I can take
renewal limits.
Renewal. If I can take Your Lordship to page number 6 of the additional affidavit, Lordship.
Oh. When was it filed? So
My
this
Lord,
objection
if
was
I
taken by you in
concede it,
the
Lordship,
the first instance.
Yes, my Lord.
Yeah, then?
My Lord, if I can take Lordship, Lordship's order was passed on 2nd July 2026. When we had raised objection, the petitioner had conveniently filed their renewal.
Yes. So
hence, my Lord, on the date,
when they filed that,
my Lord, page number 6, my Lord, of the additional affidavit, annexed 2.
Yes. Page number 6. This certified resident has applied for renewal on 2/7/26. Renewal as per is so it's renewed.
Amit, this is your I'm sorry, Your Lordship. Amit, this is Your Lordship. Lordship, at the time when this writ petition was filed, Your Lordship,
yes.
the petitioner, Your Lordship, is not a registered organization, Your Lordship. So, in that view of the matter, even Your Lordship, a non-registered organization will have no locus to maintain a writ petition, Your Lordship.
Now the situation has changed.
No, Your Lordship. What I mean to submit, Your Lordship, is at the time of the filing of the writ petition, the writ petitioner, Your Lordship, does not have a locus and cannot maintain a writ petition. Why, Your Lordship? Because it is not a registered organization.
Okay, then.
It does not exist, Your Lordship.
But now they've renewed, so.
It is renewed, Your Lordship, when, Your Lordship, at the time when the order passed by this.
Right, so they've corrected the defect. The thing is that now,
on 2/7, Your Lordship,
can we allow this technicality to what do you call it, to frustrate the entire case?
Lordship, they can withdraw and refile it.
Why should we go through the hassle?
They refile it, Your Lordship. As I have submitted, Your Lordship, as on the date when the writ petition was filed.
Fine, we'll overlook
they cannot
that.
Maintain.
We will
they
record
cannot
that.
maintain, Your Lordship.
We'll record that, but I think that since the registration since been revalidated, And so we take that prescription on board.
That revalidation, Your Lordship, was took place when, Your Lordship, on the date when that preliminary objection was raised by the state. So they immediately they file for renewal, Your Lordship, and got it pure, Your Lordship.
Yes, Vijindal.
Yes, Lordship.
What do you have to reply to somebody?
This is my petition. Allow me to.
No, repetition,
2 minutes time. Your Lordship will see.
Let's hear what
Lordship, yes.
Lordship will just have a look one judgment 2006-11 SCC 624.
Six to four.
Para 15.
Para 15.
16 and 17.
15, 16, 17.
17.
Which one?
2006-11. Yes. While passing the impugned order, the High Court did not notice the relevant provision of the 1975 Act. This was a state act. Similarly, Your Honor, in Meghalaya, we have the Meghalaya Society Registration Act, and there is also a central act which is called Society Registration Act 1869. I read further. The councillors representing the party for one reason or the other did not also bring to the notice of the High Court the effect of the provision of the 1975 Act vis-a-vis the 1860 Act. The society, presumably keeping in view the nature of its activity, was required to be compulsorily registered. It is, however, not in dispute that it was so registered under the Central Act of 1860. Once it is held that the society was registered under the 1860 Act in terms of Section 53 of the 1970 Act, it shall be deemed to be registered thereunder. The effect of legal fiction is well known. Legal fiction created, it is treated, must be given full effect. We have noticed herein above some of the provision of the 1975 Act. It undoubtedly is a complete code. It not only provides for the mode and manner in which the registration of a society is to be cancelled, but also for winding up of the society and removal of a defunct registered society from the register maintained by the Inspector General of Registration. A society need not necessarily be held to have become defunct only because certain statutory provisions have not been complied with it. Then we fail to understand as to why the Inspector General of Registration, who was impleaded as a party in the suit, also did not bring the relevant provision of the Tamil Nadu to the notice of the High Court. The
please stop there. Now, this case is because no one brought on notice. And so, okay, fine, we deem it legal fiction, it's registered 1860 Act.
Nice.
Already brought it at the initial period.
No, Lordship,
whether your correction can be allowed.
I'm coming to that.
Yes.
Simply because a society is not registered. First of all, this is, let's assume for a while,
yes.
But my case is that it is registered. Assuming that it is not renewed, then what happens?
Yes.
It is the power vested with the registrar of the society to declare this society as non-est, and that power is under the Meghalaya Society Registration Act. If your Lordship sees Meghalaya Society Registration Act, for every contravention, the penalty is provided. Your Lordship will see first registration, this Section 7. Section 7, the subsection 3 says, an appeal shall lie to the state government against an order of the refusal.
This doesn't concern this.
Lordship, I am just coming. Now, first thing is this, your Lordship, the Meghalaya Society Registration Act does not speak about the renewal of the society. It does not speak.
What does it speak of then?
It speaks about dissolution of the society, which is, and dissolution can be either by the regulation under section.
The renewal is without any authority of law.
Without any authority of law.
Then it is. Then your case goes.
Yes, without any authority of law, but in practice they are doing it. But otherwise.
Where's the renewal clause?
Pardon, Lordship?
Where's the renewal clause here in this Society Registration Act?
Society, there is no renewal clause.
Then?
There is no renewal clause.
So once registered?
It is registered. It was registered. And because of the practice which they are, because in some of the state act, like in Arunachal, Manipur, there is a specific provisions, Lordship, for renewal, And so far this act is concerned, the power is vested to the society itself to dissolve the society by a regulation.
Right. No, that's a different aspect. Regarding this dissolution, whatever society has said, then goes to another society that has like-minded. That's a different thing altogether.
Yes.
What we are on is whether, now you're arguing against yourself, you say that when it was filed, you produced a certificate registration which had an expiry date that of 2016. Correct?
Yes.
Now they take objection to that, saying that you're unregistered organization now, so you don't have the legal competence to prefer a petition on behalf of the society.
Yes.
Correct. That's number one. So after that, then that objection was raised. You went and got it renewed, and the renewal was done by the whoever. And then the things are now you're saying that this is an invalid renewal.
No, I'm not telling your Lordship this is invalid. This is not invalid.
There's no power for renewal.
Your Lordship, I'm not telling this thing. That this is a invalid. That's what your Lordship. I am not telling that.
Then
this is not what I am telling your Lordship. The Act does not provide so.
Then,
but they are following.
So that means it's without any authority of law. The renewal.
Yes, Lordship. It may be construed in that manner.
Yes.
And how they are following. This is for my learned friend to answer it. And your Lordship will see in the judgment itself, your Lordship, if your Lordship allow me 2 minutes, just to complete the paragraph 17.
Yes.
Having regard to the provision contained in section 53 thereof, once the society became a society registered, all the consequences arising from the foregoing. In the event the society become defunct or other statutory requirements were not complied with by the members of the society, penal measures could have been taken, but in no situation the election of the office bearer could have been set aside. Right to contest an election of an office bearer of the society is a statutory right of the member thereof. Such a right also exists under the bylaws of the society. It is not the case of the respondent that the bylaws of the society are invalid in law. Once a valid election was held, the High Court, in our opinion, could not have directed setting aside of the election, your Lordship. Just have a look, your Lordship, on 2 lines of the paragraph 18. There is therefore no reason as to why the elected members should not be allowed to carry on the activities of the society, wherefore they were duly elected. Here the question was that elections were held, society was defunct, and it was not so declared, and the election of the society was challenged. Then the High Court has the election is invalid. Matter went to the Supreme Court. Supreme Court said that no.
Supreme Court said no because that may be not registered under 75 Act, but the fact remains that it was a registered society under 1860 Act.
Yes.
And so the thing legal fiction that it will consider that society Yes, registered society.
Yes, Your Lordship.
And so that follows
and there is
whatever elections were held. If I understand, maybe I might be wrong, but that's my understanding of the judgment. So whatever actions happen after that,
yes,
is taken to be an action taken by a society.
Be that as
so,
it may be.
By the society, any action, and so the elections that were conducted also held to be valid. So the court has at the outset said that.
Be that, Your Lordship, as
now
it
in
may
your
be.
case, it's totally different. The judgment not applied to your case. Your case, you have to show.
According to
now,
maybe Your Lordship, my understanding is a little poor.
My understanding is poor, maybe, but as per your case, this,
I have understood in
help the court. The thing is that you came before the court with petition.
Yes.
Society's registration expired.
Yes.
Correct.
Yes, Your
Now,
Lordship. Registration, Your Lordship, was already applied. What has happened?
No.
The renewal was already applied.
Please listen.
Yes.
Please listen. At the appointed day when you came before this court and filed the petition, there was no valid registration in your name. Correct? Then after objections were raised, you went.
I took the leave of the court to file a additional affidavit to bring it on record. Because Your Lordship.
See, we prepared to accept also. Please listen. That, it's fine. That is all right. They will come to register. Now you're arguing that there's no power for renewal. So this renewal that was given to you, which you had applied. And
yes, Your Lordship, I have applied. Your only thing, Your Lordship, I am just pointing out. I'm just, there may be some circular which I am not aware. And Your Lordship will see that here the writ petitioner is not coming in his personal capacity. And here Your Lordship will know in every situation. What happened, the secretaries are appointed for a limited period. Now, secretary goes and comes.
Now you're going on a different tangent.
No, I'm not going.
With due respect, thing is that now you're saying the renewal is it's worth nothing. Now, your registration is expired.
If Your Lordship hold that this renewal is nothing, then my earlier registration stands.
No, you said that there's no power for renewal. And
that is why, Your Lordship, here, Your Lordship, my prayer is also very limited. Your Lordship will consider. Your Lordship will just consider. So here are the small people.
Mr. Jindal, do you accept that yes, there's a power of renewal, even though it's not there in the Act?
No. Yes, Your Lordship. There may be some circular which I am not aware.
Maybe it's worked into the.
Yes, because they have been renewing it. They have been renewing.
What is the is it renewed for the society?
Lordship, in fact, if I'm not mistaken, Your Lordship, there is a rule mandating every society registered, every organization registered under the Meghalaya Registration Act of 1983 required to be re-registered every 3 years, Your Lordship. If Lordship, for the moment, if Lordship kindly have the additional affidavit filed by the writ petitioner.
No, if there is such rule, Your Lordship, then if the Advocate General admits, I have no problem.
If Lordship kindly have a page
no problem that there is a rule.
Yes, sir, allow me to.
Yes.
Yes, sir. Lordship kindly have page 6. If Lordship kindly see, this is to certify that society so and so. The society has applied for renewal or 27. Renewal approved on 8/7. This certificate of renewal shall remain valid up to 7/7/2029. 8/7/26 to 7/7/29, Your Lordship. 3 years. Because as I have submitted, Your Lordship, there is a rule, Your Lordship.
Where's the rule?
Lordship, right now I don't have the rule.
We'll have tomorrow.
If Lordship takes up the matter tomorrow, I'll produce that rule.
Yes. As an issue regarding the registration of the petitioner society has arisen, especially on account of submissions of Legislative Council with regard to the power of the registrar to afford renewal. Let the matter be passed for the day to allow the additional application to come out instructions.
But Lordship, so far that submission is
tomorrow, Your Lordship. Tomorrow.
That is not. There is no pleading, Your Lordship, in the writ petition.
Doesn't matter. This is for
Lordship.
the court.
Lordship, yes. Highly apply, Your Lordship.
Hearing from supplementary list item number 7.
Wait, please, minutes. That arbitration section 11 matter, minutes.
You know, my learned friend Melitz has placed 3 decisions before your lordships yesterday.
There's not a later decision also, 26, I think.
2026 Melitz.
26 minutes.
Yes.
26 Melitz I have not. Okay.
Anyway.
Melitz, I would...
They were to discuss this Arif Azim also.
Well, it's Arif Azim has been clarified in crispening, and I'll take your lordship to
bring it. Yes.
Or if your lordship so please, Melitz, I can take, address your lordships with the 2026 decision also, Melitz, because since this will also set the law, we can try and point out the 2026 decision also.
Yes.
We'll look it up, Melitz. I was taking your lordships through the paragraphs of interplay.
That decision is 26 and 25. Okay, 26 or 25 or so. $25 is after the decision. We'll have it tomorrow.
Melitz are referring to a 25 decision.
26 is regarding non-signatory, but that will not really have an impact here. But the other one, it might
2025
where it discusses, yes.
Melitz, then may I pray your lordships have it on Friday, and I'll also do a little.
Friday is a holiday.
Can we have it next week then, Melitz?
Not next week, yes.
Because we'll try and assist your lordships.
That's the only thing, because we have to be clear also.
Lordship.
But there's only 2 parts. With regard to, the claims is different, but with regard to whether that 11.6, when can you active, when the limitation ends?
Melitz, my humble submission is both the interplay judgment, which is a reference, and crispening, Melitz, which then discusses Arif Azim, both lay down this very same thing, that at the stage of pre-referral under section 11, your lordships, the rule is...
Will not go into the inquiry. That is the only thing, lordships. That is
the only... The lordships are very succinctly put it, Melitz. They say that the inquiry is that whether there is an arbitration agreement. That is the rule. In exceptional cases where, Melitz, it's a dead claim or a non-arbitrable claim, that should not pass under section 11, Melitz. That's the only limited test your lordships can apply. That is not the case.
Because to our understanding is that, it's limited... Considered very limited. 11.6 we're not to go into.
It would be open for them to raise it under section 16 before the tribunal.
Lordship can definitely examine very glaring dates, my lord.
No, that will examine, of course, everything peculiar. But the thing is that whether, the other consideration is, suppose a claim becomes a stale claim, right? Whether by referring it up, whether we're subjecting them to some harassment. Because it's a commercial.
Because whether it is stamped or not, whether the signature is proper or not.
The only issue here is, that's why I had pointed out yesterday also, the lordships are very clear in using a certain expression. What fell for my lords is, if it is a stale claim, they say, Melitz, not a stale claim. If it is a dead claim, stale, Melitz, after a certain period would become dead. So till the period it is stale, your lordships will not look into it, because because in crispening again they say, Melitz, these again will be mixed questions of law and fact, which can be then decided by the tribunal only. If it's a dead claim, it's a non-arbitrable claim, Melitz. After 20 years I come before your lordships and I try to invoke arbitration.
Throw it out.
Yes, no. We'll try and also point out the 25 decision.
Do some research.
We'll do the research. My lords, may I have it next week, Wednesday, Melitz? Wednesday or Thursday next week?
Yes, Wednesday, 29. This matter for further hearing on 29/7.
29/7, Melitz. Obliged.
Hearing daily list item number 25.
Yeah, Lordship, this is a case where my lord have already decided in another case, Lordship. This is covered by the judgment of the Home Guards volunteers. They were denied the revision of pay. That is the last revision of pay. All throughout they have been paying, but the last revision of pay were denied to them. They have approached to this honorable court. So here the petitioner is the wife of another deceased employee, Lordship. He died in 2020, Lordship. So after the judgment, he has approached this honorable court and he is relying the judgment.
Was he party in the earlier case?
No, my lord, no. But he was an employee of the same.
He is seeking the same benefits.
Yes, Lordship.
Identical. Yes.
No, Your Lordship, the only difference here is that, Your Lordship, the appointment order of the petitioner here, Your Lordship, does not state that they will be entitled to revision of pay. However, in that previous matter, Your Lordship, it was clearly stated that they will be entitled to revision of pay. That is the only difference here, Your Lordship. Because our stand is that, Your Lordship, they are home guards, Your Lordship, so they're volunteers only, Your Lordship, so they're not entitled to revision of pay.
But ever since his appointment, Lordship, all throughout, he has been given the benefit of the earlier revised pay scale, Lordship, revision of pay benefits. Now that has been on record, Lordship. My Lord will kindly see the appointment first, Lordship, what my friend is referring, Lordship.
You sit down, we'll hear you. Yes.
That appointment is at page 11, Lordship, Annex 2.
Yes.
My Lord will see the scale of pay. What my friend is saying, because in the earlier writ petitioner's case, their appointment, they have mentioned the revision of pay, so and so. But here the full scale of pay has been mentioned. Consequent on the date of Sri so and so, a guardsman at PSC Joai, Sri Chitan Dakhar, a trained home guards volunteers is appointed to a officiate as guardsman at PSC Joai in the pay scale of so and so, so and so. This is a regular pay scale, Lordship. Now, because the revision of pay was not mentioned in this appointment.
What about the other appointees also?
They have mentioned that they are admissible as per revised. They have
enclosed the appointment order in the
enclosed, Lordship. I'll come to that, Lordship. Now, Lordship, after that appointment, Lordship, next revised pay, Lordship will see at page 13. Serial number 8
is Chitan
Dakhar. Now 1, 2, 3 were the petitioner, Lordship, in the earlier writ petition. Now from 1999, Lordship, onwards, Lordship,
been given the benefits.
Given the benefits. Here what happened, Lordship, he has filed the representation during his lifetime, Lordship, along with the petitioners in the earlier writ petition, Lordship.
Yes.
The writ petition, that representation will file at page, Lordship, 15. Serial number 6. Then he died during the COVID. This is he died February.
He died before COVID.
Before COVID, Lordship, February. Now, my Lord I'll just refer my Lordship judgment, Lordship. Why my Lord has granted benefit to them.
Next year?
Yes, Lordship.
Yeah. Yes.
I'll just read paragraph 5, page 26. They have raised all the objections, saying that they were not entitled. Having heard the learned counsel for the parties, the only point for determination in the writ petition is as to the entitlement of the writ petitioner to claim to their claim that they are allowed the benefit of pay and allowances as per the 5th Pay Commission. It is to be noted that the respondent number 1, 2 and 3 had entered service, petitioners. Service having been appointed since the year 1986 and the petitioner number 4 since 1996. Though the initial terms of engagement describe their appointment to temporary, the uninterrupted surrendered by them in a considered view of this court has vested them to a form of permanency. Now, another aspect, a fact that cannot be ignored is that notwithstanding the order of appointment allowing the petitioner to pay the revision, the petitioners are entered into service as volunteers, and it has been disputed that on entering the service the pay and other benefits was the liability of the requiring agency on the volunteers being deputed to such organization. As such, on their service no longer being required, their this engagement is not a point of issue for them to raise or any other claim for their continuing service, because subsequently during the pendency of the writ petition they have been disengaged. Then I have filed a writ petition. That low court said that this is not the issue before this honorable court. Now the operative part. Coming to the main issue in question here, again, as provided earlier and submitted by the learned counsel for the petitioner in the order of appointment, the scale of pay has been described, which was admissible under the revision so and so. Now next para, Lordship. Subsequent orders, namely the orders dated nil 1999, that next revised pay I have shown earlier, Lordship. The benefits of the third pay commission has also been extended to the petitioner, and thereafter, similarly on 2010, the benefits of the fourth pay commission was also allowed. This being the case, it can clearly be seen that the respondents in the engagement in the petitioners writ petitioners had allowed the pay revision as admissible in terms of the appointment order, and therefore to now raise the question as to the entitlement with regard to the scale of pay as admissible under the recommendation of the fifth pay commission in the considered view of this court cannot arise. My lord, subsequent benefit they have already allowed, third, fourth, now on the fifth they are disputing, and the employee has already died, Lordship. Now she will get the benefit only for 3 years, Lordship, from 17 to February 2020. So this is a covered case of the judgment, Lordship. So I pray that my writ may be allowed, Lordship.
Yes.
Your Lordship.
Where's the affidavit?
Affidavit was filed on the 17th of December, Your Lordship. Your Lordship, we've stated that the husband of the petitioner was appointed on a purely temporary basis, Your Lordship. Moreover, Home Guards, Your Lordship, is a voluntary organization.
No, that we can't, that argument is not open anymore because
Yes,
of
Your
the
Lordship.
judgment. This finding is there. Yes.
Your
With
Lordship.
regard to the entitlement for revision of pay, that's all. Where
Your
we said.
Lordship, we've stated that in paragraph 8,
Distinguishable how?
Your Lordship, that
Para
the revision of paragraph 8 and 9, Your Lordship. Paragraph 8, we've stated that the revision of pay rules is clear, Your Lordship, that it shall not apply to persons who are not in whole-time employment, Your Lordship, which is the petitioner's husband here, Your Lordship. Your Lordship, just because previously the revision of pay was erroneously given to them, Your Lordship, that cannot be allowed to continue. Moreover, Your Lordship, because that revision of pay was not specifically mentioned in their appointment order as compared to the appointment order of these other petitioners who had approached this court, Your Lordship. That is the only difference, Your Lordship. We've stated that the benefits under the revision of pay was erroneously given to them, Your Lordship.
My lord, the contention raised in this writ petition as well as the earlier writ petition is the same, Lordship, save and accept the appointment,
Except
Lordship. Appointment. Because in the appointment, that.
But only one thing, you allowed revision along with the others.
Yes.
Till the date you retired.
Yes, not died, Lordship. He died on 2020. That.
Till the last pay revision.
Yes. That is why when I was.
You prayed for pay revision, they disengaged you.
Pardon?
After the other cases, when you prayed for pay revision, they disengaged you.
Yes,
When
Lordship.
you asked for the fifth Meghalaya pay commission to be extended.
And my lord have granted 1 lakh as a compensatory for the disengagement, Lordship.
Each of them?
My lord, 3 have approached this honorable against the order of disengagement.
They got 1 lakh each.
My lord has compassion enough to grant 1 lakh each. Then here, when the benefit of last pay revision was denied, they are not giving, then the husband of the petitioner along with the other home guards file a representation.
That's the only thing. See, the other appointment can, see, everything stems from the appointment order. Whatever your rights flow from there only. Correct. Now, in the appointment of these other 8 people, you sure it's not number 8?
Sitan Dakhar.
He's not number 8 here. No, Misalan Dakhar. Yes, anyway. So,
Sitan is not there, Lordship.
He's not there.
Because this is 1986, Lordship. And his appointment is after this.
See, out here it says very clearly, municipal service trained home guards are appointed under the as admissible under Meghalaya service revision of pay rules.
That is why, Your Lordship, this court also allowed them.
My lord, even although
he's only one person.
Only one.
The same
Your
benefit
Lordship,
My lord,
I will have to take instructions.
my lord,
with regard to
only
that.
that part is omitted, lordship, but the rest is, my lord, pay revision.
Your Lordship, because first and
Upon
foremost,
on
this
hearing,
was
on hearing the United Council of Parties and consideration of the judgment of this court, which had been rendered in WPC number
In
37 of 2022, Your Lordship.
2022, wherein the benefit of revised pay scale was allowed to the petitioners. It is noted that the petitioner herein, though similarly situated in all aspects of the service, however, an appointment order, the appointment order does not include the facility for pay revision. Be that as it may, in view of the similar circumstances of service, this court is of the view that perhaps the same consideration can be extended to the petitioner as was allowed to the petitioners in WPC number
Your
37.
Lordship, that might open a floodgate to all the other Home Guard
my
volunteers.
lord, this is the only the only left out.
I'll
Otherwise,
have to take instructions.
Yes,
on that.
Ms. on this paragraph, this observation prays that we were out to obtain instructions just after 4 weeks. As a part matter.
Your Lordship.
Otherwise, one person.
and he will get only 3 years, lordship. 17, 18, 19, and to 2020 he died.
Obliged, Your Lordship.
27.
Yes, Mr. Hassan.
May I please, Your Lordship, the learned outgoing counsel, due to some personal difficulties, unable to.
Counsel?
Mr. S. Jindal.
What's the matter about?
This is a matter.
This is with regard to the school teacher, my lord. SSA school
You
teacher.
are appearing this case. He's there in the case.
Yes, he is for the respondent number 7, Your Lordship.
Challenge the inquiry report, my lord. Inquiry was conducted.
What happened to him?
Some personal difficulties is there. That's why he is unable to be present before Your Lordship. Therefore, I humbly pray Your Lordship may be pleased after 2 weeks.
To the absence of Mr. L. Jindal, Council number 7.
Much obliged.
Deeply obliged.
67.
Lordship, I'm praying if this matter can be taken up after a week. Lordship, this matter has come first time for hearing, Lordship.
Mr. Pala is ready.
No, Lordship. Senior Arguing Counsel is in Lex in court number 1, Your Lordship. Ma'am Nakishala, Your Lordship.
Yes, I'm going to pray with the Chanda. It's a matter for 2 weeks.
70.
Yes, your objection to adjournment.
Lordship, because I have small submission, Your Lordship.
Matters become treacherous.
In fact, when we had preferred this contempt, Your Lordship, there was no speaking order. So now, during the course of proceedings, Your Lordship, we had got a copy of the speaking order, Your Lordship. So now, since the speaking order is there, Your Lordship, then we will take necessary steps. So far as this contempt is concerned,
Yes,
can be closed.
I'm going to pray that this contempt will be closed at this stage.
Lordship.
Due to certain developments. Submission noted, contempt stands closed and disposed of.
Hello, Lordship.